Good afternoon and welcome to Chartered Accountants Hall, where we're presenting this ICAEW webcast live in association with Bluefin Professions and Beale & Company Solicitors. Today's topic is risk management and professional indemnity insurance. What's in it for me? My name's John O'Donnell. I'm the practice consultant for ICAEW's Practice Support Services. I visit practices to undertake compliance reviews and provide consultancy for the Institute, so I've got a professional interest in this presentation when I help discuss risk management with you as members on the road. I'm also your moderator for the webcast, and I'll be introducing today's speakers and putting your questions to them throughout the end of the presentation. We want today's session to be an interactive one, so please take the opportunity to send in your questions as we go. We'll address as many of them as possible during the webcast. The questions will be kept private, so only you and we will see them, not the rest of the audience. There will also be a short 5-question survey which will pop up at the end of the event, and it will really help us if you'd complete it for us, please. Today's speakers are Neil Williams, a Claims Director from Bluefin, and Joe Eisenberg, who's a partner in Beale & Company Solicitors. Neil's got extensive experience dealing with professional indemnity claims in relation to a variety of professions, including accountants, and has worked for a number of insurers in the London insurance market as a PI claims specialist. And at Bluefin, he manages a team of highly experienced claims handlers. Joe has also got a great deal of experience in the professional indemnity market, defending PI claims on behalf of both insurers. He's a partner in Beale & Company and defends large and small claims against accountants and other professionals, and assists accountants and solicitors in defending negligence claims and professional claims. So I will hand you over to Neil and Joe.
Good afternoon all. Thanks for the introduction, John. As John mentioned, it's myself and Joe Eisenberg talking this afternoon. You'll be able to tell who Joe is by his Australian accent and the use of sporting analogies for pretty much every scenario. So, the purpose of this talk is to consider why we need to think about risk management in the context of professional risks and professional indemnity insurance, to provide some basic pointers as to how to reduce risk, to comment briefly on your insurance policy and some of the key issues to be aware of in relation to that. And finally, Joe will talk you through some professional indemnity claims examples, which will hopefully put some of the themes of the talk into context. So why think about risk management and professional indemnity insurance? Well, the reality is, as any of you who have been in the unfortunate position of facing a PI claim will know, that they are time-consuming and expensive to deal with. Costs can escalate dramatically and disproportionately and have a significant impact on your business. If you face a claim, you will also be responsible for a policy excess and could face a rise in premiums. The good news is that the insurance market for accountants is relatively benign at present, certainly in comparison to other much more volatile areas such as surveyors, solicitors, and even IFAs. And I don't personally anticipate that changing in the short to medium term. Having said that, in the unfortunate event that your business does face a significant claim, or it is believed that there are systemic failings in your business practices, for example, then there will inevitably be substantial premium increases. Just to draw this together and put it into context, Joe's now going to talk you through the chronology of a claim and the processes involved in dealing with a claim. This should give you a sense of what can be involved in a PI dispute.
Neil, thanks very much for that. I'm firstly going to talk to everybody about the chronology of a claim and how it progresses. Dealing with a claim can be a very time-consuming process for any professional. If someone wants to make a claim against a professional, they're supposed to follow the pre-action protocol for professional negligence prior to issuing formal court proceedings. Under the pre-action protocol, the claimant is supposed to issue a detailed letter of claim. That letter of claim is supposed to set out in a clear and concise way the factual background to the claim, the allegations against the professional, setting out what the professional has done wrong or what the professional has failed to do, There should also be an explanation in the letter as to how the alleged error has caused the loss. And finally, the claimant should set out in detail an estimate of the financial loss that they say they have suffered as a result of the accountant's negligence. Often, but not always, this is the first time a professional will know that a claim is forthcoming, and if they've not done so already, insurers should be immediately notified. When the professional receives the letter, they have 21 days to acknowledge receipt and a further 3 months to prepare a detailed letter of response. The letter of response should deal with all of the allegations made against the professional, and where any allegations are denied, explain the basis for that denial. If the professional does not make an offer of settlement at that stage, the claimant is allowed to commence formal court proceedings, although the parties are encouraged to consider whether some form of alternative dispute resolution, like mediation, should be considered. As you could imagine, this is a fairly time-consuming process for the professional, and a lot of the time spent dealing with claims could, of course, be better spent earning a fee. Bearing in mind the time-consuming nature of dealing with claims against a business, as well as the financial implications like having to pay an excess and a possible increase in future insurance premiums, good risk management can help to lower the risk of claims being made against your practice. Of course, any risk management exercise always involves a degree of cost-benefit analysis. At the end of the day, professionals are in the business of making judgment calls and giving advice. If a professional becomes too risk-adverse or cautious, it can impact upon the advice that's given. Equally, putting in place some simple risk management techniques like ensuring that all advice is recorded in writing and ensuring that engagement letters, setting out clearly the scope of any professional engagement or issue at the start of a retainer can help to reduce the risk of claims. Of course, occasionally claims come along that do involve an element of bad luck. You might make a small mistake on one file in 100, but that happens to be the file where the mistake that's made causes significant financial loss. Many years ago, I dealt with a case where an auditor was involved in an audit of a surveying client who had to adhere to various rules set by the RICS. The auditor needed to exercise a judgment about whether certain bank accounts held client money. At the start of the retainer, they decided that a particular bank account didn't hold any client money. Unfortunately, in subsequent years, it was that bank account that a bookkeeper was using to fund a gambling addiction. And significant losses occurred because the auditor should have been auditing that particular account and detected the mistake. They could have made a similar mistake on many different bank accounts, but it was to a certain degree a slight element of bad luck that it was the one account that they weren't looking at that was being used to perpetrate the fraud. However, many claims aren't caused by bad luck, and before you think that it's all a matter of bad luck that causes claims, my first sporting analogy, as Neil alluded to, the more I practice, the luckier I get. There is some dispute as to whether this quote came from Gary Player or another golfer, such as possibly Arnold Palmer, but the point of the quote is that in response to a question about his lucky putting, Gary Player suggested that his ability to sink long 30-foot putts wasn't because of luck, it was because of the amount of time he spent practicing on the putting green. There is an analogy here to risk management. Better risk management techniques will lower the risk of a claim arising from a mistake involving some form of bad luck. You lower the amount of errors, the likelihood of claims is reduced, although they can never be eliminated. I'm now going to throw back to Neil, who's going to be talking about the way in which claims are dealt with.
Thanks very much, Joe. As mentioned earlier, I'm now going to run through some basic risk management pointers. I'm sure that you will think most of these points are just basic common sense, but the reality is that the majority of claims can be avoided through simple procedures. Some of these suggestions will undoubtedly involve more admin, but they're still definitely worth following. Issuing engagement letters and following them. It's important to say what you're going to advise on and what you're not going to advise on. If you're not advising a client on tax issues, then it's best to actually say that to the client. We see many cases where a client says that they thought they would be advised on such and such issue, but it was never the intention of the accountant to do so. Confirming all new instructions in writing and keeping the client advised on costs. Message here, I suppose, is that to manage the scope of the work that you're doing for the client, they need to know the cost implications of the work you are doing. I'm sure Joe would agree, but disputes and even false allegations of professional negligence can come out of the woodwork when a client is unwilling or indeed unable to pay fees. Recording and following up all advice in writing. Keeping clear notes of all key meetings and conversations. The reality is that having decent records can stop a claim in its tracks. Unfortunately, if you do not have records and there's dispute over what advice was given, which I should note can often arise several years after work has been carried out, the reality is that your client or the claimant's version of events is likely to be preferred, and it's definitely worth bearing that in mind. Joe, I don't know whether you've got any comments on that, because it's such an important point in the record keeping.
Yeah, that's right, Neil. Of all the risk management tips that we're going to go through in this webinar, I personally think the single most important one is to ensure that any advice that is given is actually backed up in writing. I've dealt with numerous claims where the accountant may not have necessarily given the wrong advice. It's just that the accountant and the client have very different recollections of what happened at a particular meeting or a phone call. Remember, when claims are made, it will often relate to advice given 3, 4, or even 5 years previously, and people's recollection of events that long ago are often unreliable. The claims examples that I'll talk about later on are going to highlight a few specific cases where a simple attendance note or an email following a meeting to confirm the advice given may have eliminated the risk of any claim arising altogether. One of the common examples that we frequently see is where the HMRC will levy an unexpected tax liability following an investigation or an inquiry. Often the professional accountant's client will say that they were not warned of the revenue conducting an investigation or perhaps not accepting a tax relief claim. Often the accountant will maintain that the client was aware of the risk, but if it is not detailed in writing, it can sometimes be very difficult to prove that the advice was given. Back to you, Neil.
Thanks, Joe. Ensuring that your diary system is up to date is also a really worthwhile thing to do. Missed deadlines can create all sorts of issues. If you have partners, make sure you have a centralized diary so that they can pick up your work in the event that you're unexpectedly absent from the office. It's common sense, of course, but it is worth making sure that you have appropriate systems in place. Adding to that, advising clients in writing of the risks if they do not meet deadlines is vital. If there are tax deadlines, for example, issue reminders to the client and then more reminders. Take a real belt and braces approach to that. Keeping up to date with developments and trends in your area of expertise is also really important. Don't advise on subjects you're not familiar with. It's obviously easy when you have clients you work closely with to start straying into areas where you don't have the relevant expertise, or if you're trying to develop new client relationships. I think Joe has an example of a recent court case where the client of a defendant accountant should really have been advised to see a specialist tax consultant. Over to you, Joe.
Thanks, Neil. Yes, there was a case recently called Maydew and Harb & Barker. That case involved Mr. Maydew, who is an Iranian non-domicile who first came to the UK as a refugee. There's been significant comment on this case in both the accountancy and the legal press, and also the Daily Mail, who had a slightly different take on the case. Very briefly, the claimant sold a business in April 2005, which triggered a capital gains tax liability of about £850,000. He asked his accountant about minimising the capital gains tax liability. The accountant advised the claimant to invest in a capital redemption plan to create a capital loss and avoid the tax for which the claimant would otherwise have been liable. Unfortunately, the capital redemption plan failed, and tax, interest and penalties were subsequently due to HMRC. The claimant said that the accountant should have advised him to seek experts' advice from an advisor specialising in non-domiciles who would have advised him to enter into a different tax avoidance scheme that would have succeeded. There were many issues in the case, but the court did not expect the accountant to have been an expert on non-domicile tax avoidance schemes, but as the accountant was specifically instructed to consider ways of mitigating CGT and knew that the claimant was non-domiciled, he should have advised him to take further advice. That case is on appeal. The important point from a risk management point of view is that if you're advising a client upon an issue where you may be unfamiliar with that particular area, consider whether or not the client should be advised in writing to consider taking some further specialist advice. I'm now going to hand back to Neil, who's going to go through some more tips on risk management.
Thanks, Joe. Salutary tale there. Moving on. Not getting too close to your clients and vetting new clients. Well, what do I mean by that? We all like to build strong and close relationships with our clients, but it's all too easy for them to unravel when things go wrong or there are significant sums at stake. The point I'm trying to make here is, even if you do have strong relationships, make sure you still follow all of your internal procedures and make attendance notes of advice given. If you were giving the advice on the golf course or over a pint, it's still important to make those notes. Likewise, do have a look at the new clients you take on. If they've just fired their last 3 accountants, find out why and what the issues were. Just make sure that you're not taking on a bit of a poison chalice. Just wrapping up the final few risk management pointers. File audits and peer reviews are a very effective mechanism for ensuring that files are properly maintained and consistent advice is given. And it's really worthwhile conducting those file reviews and on a regular basis. Also, having good financial controls to manage aged debt is crucial. As I mentioned earlier, an unwillingness or an inability to pay fees is all too often a precursor to an allegation of wrongdoing or even a spurious professional negligence claim. Effective management of debt can often reduce the risks associated with that. Having procedures in place to manage conflicts of interest is also very worthwhile. If for example, you're advising 2 directors of a business on their affairs, make sure that they're both comfortable with that and they both accept the scope of your role. One last area I just wanted to mention briefly was cyber liability and document security. It's not strictly speaking a professional indemnity issue, but it is worth considering at the same time in the overall context of risk management. We've all heard stories of laptops being left on trains and big bin bags of sensitive data being left outside banks. There's little doubt that these issues are going to continue to develop, and we'll often hear these stories in the news. It's important that you protect your client's data. Just think about things like, do you use passwords, encrypt USBs, and make sure that all of your files are secure? In the future, there are going to be increasingly strict rules and regulations in related data management. For example, there is new draft European data protection legislation, which should come into force in the next couple of years, and it's best to be prepared for that. Now I'm going to hand back to Joe again. He's going to give you a rundown of some of the causes of claims against accountants.
Thanks very much, Neil. Before I get on to that, I'm going to actually talk to you about the time that it takes and to expand upon the time-consuming nature of dealing with a claim against your practice. What this slide seeks to do is to show the time that it might take to deal with the average professional indemnity claim. Of course, every claim is different. Some are going to be more time-consuming than others. Initially, when a claim is notified, you're going to need to liaise with your broker and review the claim that has been made. Often claims relate to acts that took place 3, 4, even 5 or more years before, and a lot of times often spend in reviewing the file and checking the advice that was given. Often the fee earner that gave the advice is no longer with the practice, which means that it is even a more time-consuming exercise. This can sometimes take 2 or 3 days. Once the matter has been notified to insurers, there will be initial correspondence and possibly meetings with the insurers and solicitors they appoint in order to explain to them the background facts surrounding a claim and to assist the solicitors in putting together a letter of response. Again, this can sometimes take 2 or 3 days for a standard claim. In the unfortunate event that proceedings are issued, you'll then need to assist the appointed solicitors in defending the claim. This will often include time spent preparing witness statements and the defence of the claim. Again, this can take 2 or 3 days. A lot of professional negligence cases involve expert evidence, where an expert is required to assist the court and the parties in determining liability or quantum issues. You will often need, if faced with a claim, to spend some time liaising with an expert, and then finally there's the preparation for trial or mediation and the trial itself. Obviously every case is different, but what we've tried to do in this slide is give an example of a typical claim about the type of, or the amount of time that you might spend in dealing with a professional negligence allegation. As well as the financial considerations of dealing with a claim, like increased excesses and premiums, It's important to remember that if a professional does receive a claim by a client or a former client questioning their professional judgment, it can be extremely stressful for the professional. I've certainly dealt with claims where clients have been in tears over what in reality might be a fairly innocuous error. Again, putting in place good risk management procedures like we're talking about in this seminar can help to eliminate the time and stress of dealing with claims against your practice and allow you to do what you do best, which is practicing as an accountant. I'm now going to move on and deal with some examples of claim statistics to show you from statistics that Beale and Company have kept where claims have arisen. So if you look at the slide here, these are from statistics from claims that were received by Beale and Company in 2011. So the areas of work that produce claims, taxation and legal services accounted for about 53%, audit and accountancy accounted for about 35%, financial advice was about 6%, and other was another 6%. Moving on to the cause of claims made, inaccurate advice amounted to about 39%. Errors in the preparation of accounts was 27%. Delays, including missed time limits and elections, was 8%. Errors made in reporting to clients was 8%. Errors caused by dishonesty or fraud, usually by the client of the accountant, but occasionally by employees of the accountant, was 3%, and 15% was everything else. Bearing in mind the discussions that I've been going through about the time-consuming nature of dealing with claims, it's interesting to note that of all of the claims opened in 2011, 88% have been closed, so over 10% of those claims are still open nearly 2 years later. I'm now going to hand back to Neil, who's going to talk to you about professional indemnity insurance.
Many thanks, Joe. I'm just now going to summarise some of the issues to be aware of in relation to your insurance policy. Firstly, your policy in the ICAEW minimum terms. I'm just flagging this because as members of the ICAEW, your policy terms are already fairly broad and certainly more beneficial than the terms may be for other classes of professional. It's certainly worth familiarising yourself with the terms of your policy. Some wordings even have significant extra benefits, such as mitigation cover. This means that insurers might, in certain circumstances, pay the costs incurred in attempting to avoid a claim against you. That can be really useful. You might even have cover for public relations costs incurred in protecting your reputation when a claim against you is made. So it is worth reading through your policy. You should also, of course, check whether your policy terms change at renewal time. Moving on, one of the key points I wanted to emphasise in relation to your policy is being aware of your claims reporting obligations. I think the clear message here has to be to notify circumstances which might give rise to claims and claims themselves as soon as possible. Start that conversation with your broker and insurer. If you're unsure as to whether you should notify an issue, then discuss the matter with your broker. They'll have a sensible conversation with you about that. It's far better to tackle an issue early on rather than let it fester and potentially prejudice your position under the policy. One additional point I would make here is if you have staff who work for you or junior employees, it's a really good idea to build a culture where staff feel comfortable raising issues of concern and that if there is a problem, they're not hiding it under their desk, for example. Finally, in relation to your policy, it's worth checking that your cover is appropriate for your needs. Are your policy limits adequate for the work that you're doing and the size of the clients that you have? Is your excess pitched at the right level? Will you be able to afford to pay the excess if you have one or more claims? For example, also if you're engaging in new business areas, for example, you're providing IT services to clients, or even if you're dealing with clients in different jurisdictions such as the US, make sure that your policy is designed to respond. Always have that conversation with your broker about the scope of your cover and whether it is actually meeting your needs. If you do want to look at insurance issues and policy coverage in any more detail, the ICAEW website has a great deal of useful information, and your broker should, of course, also be able to help you. Anyway, I hope that gives you a flavour of some of the key points to think about in relation to your policy. Joe is now going to finish off with some claims examples, which should bring together some of the key themes of the talk.
Thanks very much, Neil. I'm now going to go through a range of examples of claims that have been made against accountants to give you a flavour of the types of claim that tend to get made against accountants, and try and link those claims back to some of the risk management tips that we've been giving throughout this webinar to explain how risk management can help to reduce the risk of claims occurring against your practice. Particular example, the insured accountant's area of expertise was in completing personal tax returns and the production of company accounts. The claimant was advised by a third party to seek independent advice on whether rollover relief could be claimed when the claimant sold shares in a company owned by her and her family to invest in a new startup. She approached the insured, for whom we acted. The insured was not a tax relief specialist. However, they proceeded to provide advice to the claimant and handle correspondence with the revenue as a favour to his friend's wife, even though it was outside the accountant's area of expertise. He had a brief conversation with the HMRC inspector, who said that rollover relief would apply in that particular situation. However, the advice was not backed up in writing, and the accountant did not follow the formal clearance procedures to bind the revenue that were available at the time. Had the accountant been a specialist in that area, he may have done so. The key risk management pointers to take out of this are to be wary of the scope of your retainer and be careful of advising on areas of accountancy that are outside your specialism, even if that advice is given to friends. And it's important to follow formal routes with HMRC where those routes are available to bind them. In this particular case, the accountant was relying upon a telephone call for which there was not even an attendance note or a letter supporting the contents of the conversation he had had with HMRC. Unfortunately, that was insufficient evidence to defeat the negligence claim that was subsequently made. The next example is a fairly typical claim involving a failure to adhere to deadlines. The accountant in this case failed to file their client's annual company accounts on time. Reminders were sent by Companies House but not complied with. The claimant's company was dissolved from the register, and the accountant had to pay the costs of restoring the company to the register and the loss of profits while the company was dissolved, as the company was actually able to establish that being dissolved from the register did have an adverse impact on their ability to trade. Claims against accountants are frequently made when deadlines are missed, because either the accountant has forgotten to remind their client to provide information or documentation, or is advised orally to provide that documentation, but the claimant subsequently denies having been given that advice. Claims arise where accountants have failed to advise the client of the consequences of failing to provide information. For example, the fact that penalties and surcharges may be levied if documentation is filed late, or claims where the accountant has simply omitted to file returns or tax relief claims on time. It's obviously important to ensure that deadlines are diarised for filing documents with Companies House, HMRC and other authorities, and once again to ensure that clients know of the adverse consequences of failing to comply with deadlines set by Companies House or HMRC. Frequently when claims are made, the client will say that they were simply unaware that penalties might be levied, and often a simple letter explaining to the client the impact of failing to file documents on time can help see off claims at a very early stage. The next case was a slightly unusual case against an accountant. The accountant had advised a family company over a number of years in relation to all of their financial affairs. The father fell out with one of the sons and wanted to change his will. There had been various draft wills going backwards and forwards between solicitors and the father, as well as the accountants, who advised on some IHT issues. The accountant had a meeting with their client on various business affairs, and at the end of that meeting, which was about other matters, the father pulled out the latest version of the will and asked the accountant to witness its execution. The father had attached a post-it note to the will, changing one of the legacies to benefit one son over the other. The accountant witnessed the execution of the will, thinking, quite rightly, that it was an improvement on the pre-existing will in terms of reflecting the father's updated wishes. They said that they advised the father that he should take some legal advice about the fact he had tried to amend one of the legacies by sticking a post-it note on one of the pages. The will was executed and put in the accountant's safe. A couple of months later, the father died suddenly and unexpectedly before anything had been done about the post-it note on the will, and subsequently there was a family dispute in relation to the validity of the changes made by the post-it note. That dispute between the family was settled, but at great cost to the estate, and the estate tried to claim some of the costs of that dispute from the accountant. Whilst that was a slightly unusual claim, the risk management points to take from this are firstly to be wary about straying outside your area of expertise, and secondly, and perhaps more importantly for this case, it emphasises the need to ensure that any advice given is formalised in writing. Whilst the accountant believed they had suggested that the father should see his solicitors, there was no written attendance note confirming the advice had been given, and a simple one-line email or letter following the meeting suggesting that the father should take further legal advice would have eliminated the risk of any claim whatsoever. That was not done, and the accountant was put through considerable stress over a number of years in dealing with that particular claim. Moving on to the next example, this is from an audit client. A UK company's audited accounts showed that it had £1 million held as cash on deposit. In fact, the £1 million was held by a US company that was controlled by one of the UK company's directors. Both companies went into liquidation, and the £1 million could not be recovered by the UK liquidator. The reason for this was that one of the directors had absconded with the money. The liquidator sought damages from the auditor as the accounts did not show a true and fair view of the UK company's position, and the liquidator argued that had the true nature of the £1 million transaction been disclosed in the accounts, various financial losses would have been avoided. The auditor maintained that the UK company's shareholders all knew the true nature of the £1 million invested in the United States, which was apparently for further business opportunities, but there was no evidence to support the auditor's view. Clearly, the risk management points to take from this is obviously to ensure that audit files contain proper verification and documentation. In this case, the auditor had not properly verified the true nature of the deposit, which was a fairly significant sum in relation to the company's balance sheet. It also shows that it is important that key conversations and minutes of meetings are recorded in writing. In this case, the auditor believed that the nature of the £1 million transaction was discussed at the shareholders' AGM and was well known by all of the shareholders of what was a fairly small company. But unfortunately, that discussion was not recorded in the minutes, and the shareholders subsequently denied that they knew the true nature of the £1 million. The next claims example relates to the transfer of pension benefits. We acted for an accountant who was asked by a doctor to advise on the transfer of his accrued pension rights. The doctor told the accountant who managed his practice's affairs that he wanted to transfer to a personal pension as he was going to do far more private client work than NHS work. Information was not fully recorded in the fact find, and it was disputed several years later by the doctor following the poor performance of his personal pension. Advising on pension transfers was outside the accountant's main area of expertise, and unfortunately the fact find had not been properly completed and did not record all of the information accurately, which meant that there was a clear exposure to the accountant. Luckily, in that particular case, the claim had been issued slightly out of time, but otherwise there would have been a significant payment made. The key risk management point to take from this is, again, to ensure that key points are recorded in writing and to be wary when you give advice that is outside your area of expertise. The next example involves another audit case. The audit firm had acted for this particular company for over 30 years. The company's finance director stole £2.8 million over an 8-year period. The auditor raised informally some concerns over that finance director's lifestyle with the owner of the business, but unfortunately did not record that conversation in writing, and the owner of the business subsequently denied that it had ever taken place. The auditor failed to carry out some additional checks that they probably should have done. A claim was made against the auditor for failing to detect the fraud that was being carried out, and it settled for in excess of £1 million. The auditor had made various errors in conducting the audit itself, but they had clearly expressed their concerns about the financial director's had they expressed their concerns about the finance director's conduct in writing, the possible claim might have been avoided. Again, the risk management points to take out of this is to ensure that key conversations are recorded in writing, and if there are any concerns about key employees in a financial function of a company, carry out additional checks or warn the company. And you might be pleased to know the next one is the final example, which is another sort of slightly interesting case and slightly different to the usual type of claim that one sees against accountants. This case involved an insolvency practitioner who was appointed by a builder as a LPA receiver over some property. There had been years of ongoing dispute over the redevelopment of this property, and in settlement of an earlier dispute, the builder had a legal charge over that particular piece of land. The builder tried to enforce that charge and appointed an insolvency practitioner as a receiver. The receiver, thinking that she'd been validly appointed, sold the property to a third party. Unfortunately, the court subsequently held that the builder had no right to enforce their charge, and as a consequence, there was no right to appoint an LPA receiver. The receiver had accordingly trespassed by selling the property in question and was liable to significant damages to the landowner. Of course, normally in cases like this, the receiver is protected by an indemnity given by the party appointing the receiver, which is usually a bank. But in this particular case, the indemnity proved worthless as the builder had gone out of business. The key risk management points to take from this are when acting as a receiver, to obviously ensure that all appointments are checked and correct, and to ensure that any indemnity given is solid. The key thing to take out of I think this webinar in terms of risk management is, as you can see from a lot of those claims examples, a lot of them arise because conversations have subsequently been denied, and ensuring that advice given is backed up in writing is probably the best risk management technique, or the best risk management tip that we could give, I think. So that brings us to the end of the presentation. Neil and I hope that you found this to be an informative overview of both the way in which claims are made against accountants, and hopefully we'll take from this seminar some tips and advice as to how to minimise the risk of any claims against your practice. Whilst we've been talking, we've had a few questions that have come in, and I'm going to hand back to John, the moderator, who's going to go through those briefly in the time that we have left.
Well, thanks very much, Joe and Neil. And I think that we've learnt some very important points which I'd briefly summarise to confirm the key advice in writing, that detailed file notes will certainly help your PI insurers help you. Perhaps sometimes friends for whom you might act may not necessarily remain friends if something goes wrong, and that your practice management systems can help you ensure that the deadlines are adhered to minimise any mistakes being made in submitting appropriate elections, for example. The fifth point, I think, is quite important, and that is that client engagement letters can support you, but you do need to keep them relevant and up to date. And one of the questions we've had come in, I think, focuses on engagement letters, and the question really is it worthwhile having a limitation of a liability clause in an engagement letter? So I'll just hand over to Neil or Joe. Joe, I think, would like to take that one.
Yes, it's a question that does crop up from time to time. My personal view is that there is no downside in inserting a limitation of liability clause into a retainer letter, but one has to be very careful if the limitation of liability clause is challenged to make sure that it is upheld. There is limited case law on this from the court. There is a little bit about it, but there aren't any clear guidelines. The main point is to ensure that the limitation of liability clause is reasonable. So there is not much point in limiting the liability to, say, £100, because a court is likely to hold that that's not a reasonable cap on liability. The other key point to ensure when you have a limitation of or you're trying to put in the limitation of liability clause is to make sure that's highlighted to the client and that the client fully understands the nature and effect of that limitation of liability clause. It's far less likely to be held effective if it's buried within, as clause 15 in 30 standard terms and conditions and is not specifically pointed out. But if you have a limitation of liability clause that, for example, is specifically discussed with the client at a meeting and the client agrees to the limitation of liability clause, it's more likely than not that it would be upheld by a court. Hope that deals with the query, John.
Thanks very much. The second one I'd just like to ask is making a notification of circumstance to insurers likely to lead to an increase in premium even if there is no payment made by insurers?
Thanks for that question, John. My initial reaction is it's always far safer to notify a circumstance in any event. The benefits far outweigh the downsides. Obviously, to some extent, it depends on the nature of the circumstances as to how concerned insurers might be. But certainly insurers will generally expect an accountant to notify potentially a number of issues during the course of the year, depending on the size of the practice. Indeed, a lot of insurers would be quite sort of nervous if a client didn't notify any issues at all. They'd perhaps think that risk management procedures weren't being followed and the practice wasn't actually looking out for areas of concern. So actually, in some ways, notifying some circumstances can be seen as a positive thing. I hope that answers that question.
Yes, I think it does. I think there's a question that's probably quite relevant for Joe to take, if possible, and this one is a simple question. When is a claim time-barred?
Certainly I can deal with that, and the best lawyer answer to that is, of course, it depends. But there is a talk on limitation. It could be a day's topic in itself. But I can certainly take everyone through the very basics of limitation and when claims are time barred. The first thing to consider is that there is a primary limitation of 6 years if someone wants to make a claim in contract or in tort. So for a breach of contract claim, that claim would be time barred 6 years after the mistake is made. In tort, it's slightly more tricky, but there is a 6-year limitation period to bring a claim after the cause of action arises, and the cause of action doesn't necessarily arise when the mistake is made. It actually arises when the client itself suffers loss. In the context of accountants' claims, for example, if some negligent advice is given on say, some tax in relation to the filing of a tax return, the limitation period will normally start perhaps when the tax return is filed, which might be several days, weeks, or months after the negligent advice is given to the client. But the primary limitation period is 6 years from when loss is suffered. As you would imagine, a lot of clients may not know that they've suffered a loss until many years later. For example, if they put in a claim to the revenue for tax relief that is subsequently challenged many years later, the client may not be aware of that. And there was a case many years ago involving a firm of structural engineers where there was a defect in a building that was discovered, I think, 7 or 8 years after the building had been constructed, and the court held that there was no ability of the client to recover the money because they were beyond the 6-year time period. And as a result of that particular case, there was a section inserted in the Limitation Act, which is 14A of the Limitation Act, which gives an additional 3-year period from the date upon which the client had knowledge of the facts required to bring the claim. So if the person bringing the claim is outside the 6-year period, the second thing to look at is whether or not 3 years before proceedings were issued, the client had sufficient knowledge of the facts required to bring the claim. That, I think, probably deals with the main limitation points that arise in claims against an accountant. So I'll throw back to John.
Okay, thanks very much. Now, there are a number of questions coming in that I'd just like to very, very briefly touch on. The slides will be available in 48 hours. So for those of you who are saying, can you access them? Yes, you can in a couple of days' time. I'd like to pass another question here to Neil, I think. And this question is, if there is a possible claim, you as a firm advise the insurers and brokers. But in correspondence with the client, you are told not to inform the client that insurers have been notified. Is there a reason for this? Over to Neil for that one.
Thanks, John. The answer to this one's fairly short. Essentially, the general reason that insurers do that is that they're concerned that claimants will see insurers as potentially being a pot of gold, a source of money. So that's the primary reason why they wouldn't want the claimant to know that insurers have been advised. I mean, let's hope it doesn't work out this way, but there is always the possibility the insurance might not kick in as well, so it's just worth bearing that in mind. But that is the key reason that insurers don't want claimants and potential claimants to see that there's an easy source of cash for them. I hope that answers that fairly succinctly.
Yep, thank you very much. One other question that's certainly quite interesting is, should file notes and attendance notes be shared with the client? Which one of you would like to take that? Joe? Yep. Okay, over to Joe.
As a general rule, no. We would normally suggest that file notes remain on the file. Although what the best thing to do when you want to communicate to the client the advice given, I would suggest, is to do it in an email or do it via email or via a letter. That's it.
Okay, thanks very much. There's a question here that I'll move to. I possibly know the answer to it, but I think I'd like to just ask the question of you. Is there a level of claim that insurers decide is not worth defending due to the costs in dealing with it? I don't know which of you would like to deal with that. Yeah, Joe would take that one.
That's certainly a factor that insurers will always consider, and if there is a particularly low level, what they certainly don't want to do is to pay a solicitor a lot of money to defend a case to trial, where the claim could be settled for a much lower sum and obviously with certainty. There is always a risk in taking matters to court, and that nothing is ever certain when you go before a judge. And one thing insurers do like to have is certainty, and one thing they don't like doing is spending lots of money on lawyers for obvious reasons. Is there a specific level of claim below which they will take that approach? No, there isn't a specific level. But what they will do is factor in the sort of size and complexity of the claim as against the value of the claim and how much money they may spend in defence costs versus what they could actually spend just simply to settle the claim. As a general rule, most insurers will take into account the views of the insured, but that will have obviously a certain limit. An insurer is not going to insist that a claim is defended to trial at a cost of legal cost of say £50,000 when the claim itself is worth 300 quid. They're not going to take that type of case to trial as a pointed principle, no matter how much the insured might want them to do so.
Thanks. There's another question here which certainly to me is a fairly legal question, and it is, what is the status of email and, quite interestingly, also text messages in determining whether advice is given in writing? And I don't know, I think Joe might be the person to take that, so back to Joe.
Yeah, that is a fairly straightforward answer. There isn't any difference. If you give someone advice on an email, or if you give them advice on a text message, it's just as valid as giving it in a letter. I suppose in a text message, it's obviously by its nature much shorter, so perhaps there might be issues as to whether or not what's communicated is clear or not. But I certainly wouldn't say that there is any difference between communicating via letter or via email. You can back the advice up the same way. The key thing is that the advice is given in writing and it's received by the client.
Okay, thanks very much. How long should emails be backed up for, or should they all be printed off and put on client files? Joe again.
I would recommend doing adhering to the same recommendations that the ICAEW have. Generally, the sort of rule is that you should maintain your records for, I think, 6 or 7 years. There is, in my view, there is no need to print every email out onto a file. That's not something that I do in my practice. Our emails are stored electronically, so our files don't contain copies of every single email that comes in and out, but they are stored electronically, and every single email that comes in is available for retrieval, and that data is kept for a very long time. It's obviously much easier to archive electronic data when compared to paper files, because it's much more cost effective to store electronic electronic information, but certainly they should be kept for at least as long as the recommendations by the professional body, which is I believe 7 years.
Okay, thanks very much. Now, I know that Neil's prepared to take this one, so I think we'll give Joe a minute or two's rest, because he's taken a lot of the last questions. What does the speaker mean regarding financial controls in relation to debtors? Over to you, Neil.
Thanks, John. The point just really trying to make there is to manage debt effectively. Trying to make the point in the seminar that unfortunately we see a lot of claims arise out of clients that are either unwilling or probably more likely unable to pay their bills. So they'll perhaps look for a reason, not to pay those bills, which could be a spurious professional indemnity claim. So I think keeping on top of age debts, there's clients that aren't paying and looking at the reasons why they're not paying is a really good way of sort of focusing on potential issues that might arise. And if somebody is just genuinely having difficulty paying, talking to them about that and trying to manage that process rather than letting it end up in a sort of full-blown dispute. So that was really the key message I was trying to get across there. So I hope that answers that.
Okay, thank you. Now, we've got about 5 minutes or so more, so I think we can go through a number of other questions that we've got. There is a question that's in a different way quite interesting, and it is, would you advise trading through a limited company as a way of mitigating personal liability? I think something that I see a lot of people doing is effectively trading as a limited company where you are the sole director and the sole shareholder. So if I can just sort of finesse that question slightly to say, a sole practitioner, 100% shareholder, sole director, trading through a limited company, does that help at all? And I think Joe's prepared to take that question. Okay.
As a general rule, I think it's safer to trade through a limited company from a claims point of view. Obviously, if there is insurance cover available, it probably doesn't make a great deal of difference. But the key thing about trading through a limited company rather than through as a sole practitioner is that if a claim is made, the entity that will be liable for the claim will be the limited company. There are certain limited circumstances where a director could possibly be personally liable for advice. There was a case involving a firm of surveyors many years ago called Merritt and Babb, where an employee was held liable for some advice given in his capacity as a surveyor. He was an employee of a partnership that had long since disappeared. He was held to be personally liable, and there's an argument that could possibly extend to a professional who gives advice in their capacity as a company director. But it's much safer, in my view, to practice via a limited company, albeit there are further compliance issues, accounts issues, etc., that come with trading via a limited company. But my personal view is yes, it is preferable.
Okay, thank you very much. There's a question about, are there stress support facilities to help sole practitioners facing claims? I think the answer to that one, in one sense, is that any institute member, or family of an institute member for that matter, can phone CABA, the Chartered Accountants Benevolent Association, and in situations just like that, stress, redundancy, financial hardship, CABA are very well placed to help, and they have people who will speak to you on the phone, who will help you through problems. The Institute also has support members who can be accessed by phoning the Institute's helpline, and you can get that through the Institute's main switchboard. And the support members are exempt, although they are chartered accountants, from the duty to report misconduct as well. So they are people who you can confide in. The next question is that someone is planning on closing their accountancy business and wind up their limited company. How long should they continue PI? So I think Neil's happy to take that one. Over to Neil.
Thanks, John. I think the recommended period is 6 years. That deals with most limitation issues that Joe was talking about, and your policy will probably have details in there about the premium to be paid in respect of runoff. And I'd really strongly recommend that you arrange runoff cover. It's a really important thing. I have had a really unfortunate case where the individual didn't take out run-off cover, and unfortunately they passed away. And it meant that the estate was potentially responsible for an insurance claim that came in later on. So I'd really strongly encourage you to take that up. I don't know if Joe's got any other views.
Yeah, it's not worth the stress of retiring, thinking you're going off into a nice easy life and then not having run-off cover to cover anything arises. It's also important to remember that a lot of spurious claims or claims that don't have any merit are made against all types of professionals, including accountants. And whilst there might not be any damages to pay, if you do have insurance, at least they can take over the conduct of the claim and defend it on your behalf. And I would say it's especially the case when you're retired. It's the last thing you want to be dealing with. A lot of professional indemnity policies also provide cover for disciplinary costs, and a lot of disgruntled clients, if they think that they might not have a valid claim for damages, they'll often report their former accountant to the professional body, and there'll be an investigation. And again, that's something that cover is provided for. So and the cost of run-off cover is relatively good for accountants for what you get. But it comes back to does one really want the stress of dealing with a claim when you've ceased practice?
Okay, thank you very much. I can only repeat all of those comments about getting run-off cover from my own experience of meeting people as well. It is good value for money. It's something you really should be taking, and it's very good risk management. I think we've probably got time for one more question, and that is practice consultancy fee income taken into account in working out your minimum professional indemnity limit? Yeah, Joe, I think we'll take that one. Sorry, is a practice consultancy fee income taken into account in working out the minimum professional indemnity limit? In other words, I think if you're doing some consultancy work as well as tax work, as well as audit work, I am interpreting that the question is really, do we add the consultancy fee in to get the minimum PI limit?
I must confess off the top of my head I don't know the answer to that, but I suspect that's probably right. I would have thought that it would be included when working out the minimum PI limit.
Well, my interpretation of my advice would be that if you're not sure, I think phone the broker or phone the insurance company and have a discussion with them so that everybody's giving you the best advice on the basis of the question that you're both understanding is relevant. But I would imagine that it probably would be included. I think the questioner might have a chat with the PI insurer or broker in question. I think that's probably all the time we've got. I'd like to, first of all, repeat our thanks to Neil and Joe for what I think has been a very informative webinar. The slides will be available within 48 hours. You can have a look at them. You can link into them. There are some unanswered questions, mind you, not many, and we will try and get responses sent to the questioners to who we've unfortunately not been able to answer the questions as soon as we can. So from Chartered Accountants Hall, from Neil and Joe, from Bluefin, from Beale & Co, and from the Institute, thank you very much for listening, and I hope you found this session very useful. And please will you just take a couple of minutes to fill in the questionnaire. Thank you very much, and good afternoon.